Don't nod out. It's time for the Will Wilson All Day Live Show. I haven't played this guitar in a while, but I don't care. Once upon a time you dressed so fine, through the bums and dime in your prime. Didn't you? People called, said beware, doll, you bound to fall, you thought they were all. Didn't you? You used to laugh about everybody that was hanging out. Now you don't talk so loud. Now you don't seem so proud about having ugly scrounging your next meal. How does it feel? How does it feel to be without a home? No direction, no. Like a complete unknown. Like a rolling stone. You're gone to the finest school. All right, Miss Lonely, but you know you only used to get used in it. Nobody's ever taught you how to live out on the street, and now you're gonna have to get used to it. You say you never compromise. Napoleon and race. I'll say it again.
Well, one of the things I'll tell you that I'm known for, Will, I'll tell you, I'm probably the most hated man in the Patriot community because of this email that I put out. There's actually two emails that I put out. One's called Beware False Prophets, and the other one is basically asking, are all tax honesty leaders really undercover IRS agents setting you up for a bust? In both of these emails, I give everybody the names of all the scammers in the Patriot movement, all the con men, con women, snake oil salesmen, legal lunatics, morons, dumb F-U-C-K-S, screwballs that are out there selling legal mumbo-jumbo that not only does not work but gets you in far more trouble than you were to start with had you never messed with these people. And I give you their names, and I show you Department of Justice website links with actual case numbers showing that many people have gone to prison using these fraudulent and bogus legal methods from these gurus that you find on the internet. And that's pissed off a lot of people in the Patriot community because a lot of people out there attend monthly meetings like the Legals Group, Legs in Seattle, and they really believe that these gurus have good intentions. And I ask everybody, well, what was the road to hell paved with? Can these people show you any wins? Can they show you any court case numbers they've ever won? No, they can't. Most of them are just total bullshitters. And because I've hurt their business, these people are now tag teaming and posting false complaints about me on the internet to basically retaliate against me. And so now when somebody's out there looking for legal help, who's good, who's bad, how can you tell? Well, I'll send a list of my testimonials to anybody that sends me an email showing you people all over the United States have beaten traffic tickets, not even been issued a traffic ticket in the first place, just by simply handing my flyers to the cops in a real-life traffic stop. Now, some people will scoff at that and say, oh, that's ridiculous. I've never heard of that. That sounds like BS. Well, guess what? Here's the reason why the cops pay attention to my flyers. The reason why the cops in Washington State especially pay attention to my flyers is because I wrote all of my free flyers out of the very book that they carry in their cop cars. There's a special edition of the RCW called Selected Titles, which has Title 9, 9A, and 10, the 3 criminal codes, Title 13, the Juvenile Delinquent Code, Title 26, the Family Domestic Violence Code, and also Title 46, the Motor Vehicle Code. And I wrote all of my free flyers out of that. This is what the cops, when they go to write you a ticket for speeding, no seatbelt, DUI, running a red light, they go to this book and they flip through to make sure they cite the right statute on their ticket. And one of my flyers that really catches their attention is called the Stop Arrest Flyer, because it contains the arrest without warrant statute, RCW 1031-100, and it contains 2 other statutes, a court rule, an appellate decision, and a Washington State Supreme Court decision, the appellate decision of State versus Stortrand, and the Supreme Court's decision, State versus Redding, which tells police officers in plain writing they have no legal authority to arrest and take into custody anybody for driving while suspended. So you hand that flyer to my cop, any cop in Washington State, he's not going to arrest and take you into custody, you know. But if he does, you could end up suing him for false arrest, because the way the doctrine of qualified immunity works is it operates to protect all those except those who knowingly violate your constitutional and statutory rights. So if you present a cop with a statute that says, hey, you can't arrest me for driving while suspended, you can't arrest and take me into custody, and the cop will say, well, I can arrest you. This is where they're negligently training the cops. Yes, they can arrest you, but you know what arrest means, folks? It means they turn the lights on. When a cop pulls up behind you and turns the lights on, no reasonable person would believe that they are free to leave. Okay? That's when you're under arrest, when the lights come on. But, and they don't have the authority to take you into custody for driving while suspended, and that's what my flyer lays out.
By the way, everyone, this is the All Day Live show. I didn't do a proper introduction. And we're interviewing and listening and learning and being inspired by Luis Ewing, that's his picture in the background, and his websites, cpsexposed.com, and Luis Ewing, that's LuisEwing.com as well. And then, Luis, so here we are, All Day Live. Thanks again for us having the chance to listen. And about the driver's licenses circumstance, that's, most people, it would take some courage for somebody to try to stand for that. I mean, you have, and Kurt Reagan has, and I guess Dave Merland, Myrland, and that's WEV, we versus gov, WEVGOV.com. That's what his website is. I recommend you go there. And you've worked with Dave as well. We just did an interview with Dave Merland. Myrland, I believe, I'm not sure if I pronounced that right, Myrland. Dave?
That's David Myrland.
Myrland, yeah. And then WEVGov.com, WEVGOV.com. Hey, thanks, Luis. Greatly honored again. So, it takes a certain amount of something for someone to challenge the system, right? I mean,
yeah, it does. And the problem is, they've designed the whole court system where it's cheaper to pay the tickets than it is to fight the system, because how many people can afford to miss work to go make even a single court appearance, and then not be at risk of losing their job? It's just too much of a pain in the butt. What they should do, since these people are supposed to be public servants, is make them have special courtrooms in every county 24/7, okay, so that we don't have to miss work. And if the judge has to be working at dinner time or late hours, they need to lower their paychecks so that they can hire more judges, because the judges get way overpaid for doing no service to the people. All they're doing, I'd say 95% of our court system, it's all about oppressing the poor people. It's about control. It's control of the people. And everybody says, no, the main thing is the money. Well, the thing is, they can't get the money without the control. And so what we have is a bunch of criminals who've infiltrated and taken over the government. And people say, no, it's just 1 or 2 trees. And what people don't realize is the whole forest is rotten. Okay? And nobody believes it until they get their ox gored. Okay, but I'll give you an example of what a ripoff is. For those of you folks who've ever paid a retainer, I ask people on the phone all the time, do you know what a retainer is? And they go, yeah, I give some money down payment to the attorney, and he's going to start working on my case. And I said, no, that's not what a retainer is. Here's a case. I'll read it to you guys. Baranowski versus State Bar Association. It's a California case, and it was cited with approval on the front cover of the Washington State Bar newspaper committee reports, formal opinion number 173. Quote, a retainer is a sum of money paid by a client to secure an attorney's availability to work for a client. The fee paid is considered earned at the time of the payment because the attorney is entitled to the money regardless whether he actually performs any services for the client, and the funds shall not be placed into the attorney's trust account. Baranowski versus State Bar, 154 California Reporter, page 752, or 593 Pacific 2nd, page 613, 1979. And this is what pisses the judge off, is because I'm like the little kid who points and says, look, the emperors are naked. These people are ripping us off. Okay, so you go meet with an attorney tomorrow, and he'll meet with you and speak to you for an hour or two. You think that time's free. And you're going to think, wow, he's really nice. He's really professional. He doesn't cuss or swear like Lewis. He's not rude like Lewis. But when you're done, he's going to ask you for $10,000, $15,000, $20,000, $25,000 as a retainer, for whatever kind of case you got going on. And you're going to cut him that check for that $10,000, $15,000, $20,000, $25,000, and you're going to walk out of his office thinking you hired him. I guarantee you the very next day when you call that attorney and say, I found another attorney I want to hire, I need to come back and get that retainer check, and he's going to say, I'm sorry, that money's all gone. Clearly, the case said a retainer is a sum of money paid by a client to secure an attorney's availability to work for a client. What that means is he'll return your phone call. And so I tell everybody, you want to be a sucker? You're going to pay somebody $10,000, $15,000, $20,000, $25,000 to pay for his availability, and that only means he's just going to return your phone call? Hey, if you want to be stupid, why don't you give me your money and don't worry about me not returning your call, because I'll be calling you more often because you're a sucker. I'll be calling you on a weekly basis to get more. That's what the attorneys do. They're ripping you off. Now, I charge a consulting fee. Well, people say, well, what's the difference between my consulting fee and an attorney's retainer? Well, consulting fee, I'll give you that same hour or two the attorney gives you, but here's the difference. I actually do preliminary research. I go online, pull down the latest statutes you've been charged with violating. I get in my car, and I'll drive 2.5, 3 hours, depending on traffic, to get to the law library in Olympia, Washington. Sometimes I'll drive an extra hour and a half north to the University of Washington library, which I really like it up there. It's a really, really big library. It got a lot more stuff to look through. And either case, it's $2 an hour parking, 15 cents a page of copy. I'll copy the entire statute annotated for whatever statute you're being charged with violating: drunk driving, drive while suspended, IRS charges, drug possession charges, whatever. And then I'll sit down and I'll kind of speed read through the case quotations to see if there's any cases that sound similar to your case, on point or relevant to your case. And if there are, I'll go to the bookshelf and I'll pull those books off the shelf and I'll copy a whole bunch of those cases. Then I'll go look through Amjur, Corpus Juris Secundum. I'll look through ruling case law, words and phrases. I'll look through the federal decisions, the Supreme Court decisions, state decisions from your state, or, decisions from other states. And, well, by the time I'm done, I'm going to have a couple inches of crap, and then I got to drive another, 3 hours to 4 or 5 hours to get home. And, that takes up gas money and time. And then I got to spend about a week out of my life reading case law just for your case. And at the end of about a week's time, I'll call that person up and say, hey, I've thoroughly analyzed your case. I've done the research on your case. And I'll give the person, I'll give them a realistic appraisal of where you're sitting, where you're at. And then I'll tell that person realistically what percentage chances they have of getting a positive result, one way or the other. I'll tell them what their options are, if they have any. And then and only then can I give them an estimate of how much or how little I would actually charge them the right motions or pleadings or discovery or whatever kind of document they want to try to win their case. And that's what I do for my consulting fee when I look at any case. And that's something no attorney does. They do not do any actual preliminary research. They will just blow smoke up your rear end and tell you, oh, I've done lots of cases like this before. And they'll take your 5, 6, 7 grand retainer for a drunk driving charge. And the whole time the attorney's thinking, how can I keep this money without having to do any work for this guy? And then a few weeks later, you're going to call him up, and he's going to say, well, I got you a really good deal. And I'm thinking to myself, okay, I'm about to get ripped off here. I got you a really good deal. I read the police report. It doesn't look good. You could go to jail for a year and pay a $5,000 fine. Okay, the attorney's working in cahoots, conspiracy and collusion with the prosecutors and the judges to shear the sheep, to process all you sheeple through so that they can collect your money. Okay, they're not going to stand up and fight the system. They have control over the bar attorneys. Now, because I'm not a member of the bar, they have no control over me. I'm a loose cannon. Okay, people hire me. People that come looking for me are the ones who've been ripped off by attorneys. They're the ones that are sick and tired of being ripped off and charged too much money to do literally no work or plead them guilty. Those are the people that come looking for me. And as times are getting tougher and the price of gas is going up and everything, people are looking to, find a legitimate alternative to hiring somebody who's an attorney who's a member of the bar. And I keep telling people there's nothing legitimate about the bar. Just because they're sanctioned by the government or licensed by the government doesn't make them legitimate. Okay, what we have is a legalized theft ring, a legalized criminal racketeering organization. That's what the State Bar Association is. It is a criminal organization designed to rip people off. They're milking the cow. Why do you have to go to an appeal court when you made a correct motion? Your Honor, I move to dismiss this case. It says right here in the police report, the officer ran a random license plate check. He's already stipulated on the record, Your Honor, testimony that I was not speeding. I didn't run a red light. I did not commit any civil infraction in his presence. And he conducted a criminal check on my license plate. Okay, and then he found out I was driving while suspended, illegally. He conducted an illegal search based on his claim that he ran a random license plate check. Guess what, folks? There is no statute in existence in Washington law that authorizes a police officer to do a random license plate check. Okay, but they got established of doing that through a case called State versus Martin, where the criminally corrupt prosecutors from Kitsap County, Pamela Leginsky and Jeffrey Johns, okay, these people are criminals, okay? They filed a false brief making a false legal argument into the case State versus Martin, arguing that because the license plate was in plain view, the cops could run a check on it. Well, guess what, folks? Look at your license plate. It's a piece of metal with numbers stamped on it. Can you tell me the name and address of any registered owner simply by looking at the license plate? No, you can't. Okay, so how did he find that out? Well, for the same reason in State versus Young, I explained this in an earlier show, I'm trying to point this out to people, cops do not have any authority to do random license plate checks. In State versus Young, the Washington State Supreme Court said the use by the police officers of the heat-infrared technology to see through the 2-foot cement walls, to see the 1,000 marijuana plants growing, constituted an illegal search and seizure in violation of Article 1, Section 7 of the state constitution, your rights to privacy. Okay, and that's what the police officers' use of the electronic mobile data terminal is. It's an electronic device that basically sends a signal or intercepts a signal from the Department of Licensing database in outer space. Okay, I don't think there's any human alive that could look up at the sky and pinpoint the satellite and use his brain power to pull the name and address of the registered owner of the vehicle that you're driving with his normal human vision. Therefore, the police officers' use of the heat of the electronic mobile data terminal in their car to run your license plate without you having committed a crime in his presence or in her presence, that constitutes an illegal search. Now, there's two recent cases, State versus Day and State versus Duncan, that says police officers are not allowed to apply Terry principles. i.e., they cannot conduct a criminal search of you or your car or your driver's license on the basis of the commission of a civil infraction. By statute, a police officer only has the authority limited to the specific purpose for which he pulled you over. If he pulled you over for speeding, running a red light, that means, okay, he can arrest you. That means the lights come on. He can pull you over, and he can issue you a green civil infraction. Okay? And I'm going to point out something to you folks. Everybody pays the tickets voluntarily. There's no requirement that you pay the tickets. Let me read the back of a traffic ticket, you folks. Here are the 3 ways you can respond. Check one box, then sign and date the bottom of the notice of infraction. The first one says, I have enclosed a check or money order in U.S. funds for the amount listed on the front. I understand this will go on my driving record if, quote, traffic is checked on the front. Do not send cash. NSF checks will be treated as a failure to respond. Okay. That's the first box. That's for the suckers who just don't want to, just to avoid having to make a court appearance, they decide to volunteer to pay because they're suckers and they send a check in the mail. Okay. The second one, mitigation hearing. This one's also for suckers. It says, mitigation hearing. I agree. I have committed the infractions, but I want a hearing to explain the circumstances. Please send me a court date, and I promise to appear on that date. I know I can ask witnesses to appear, but they are not required to appear. I understand this will go on my driving record if, quote, traffic is checked on the front. The court may allow time payments or reduce the penalty where allowed by law. Okay? That's for the suckers who are pleading guilty. They don't want to contest it. They just want to go in there and bleat like sheep. Bah! Your Honor, please lower the fine. Bah! Okay? Now the third one.
You've got some still here.
Contested hearing. I want to contest, and then they put in brackets, challenge this infraction. I did not commit the infraction. Please send me a court date, and I promise to appear on that date. The state must prove by preponderance of the evidence that I committed the infraction. I know I can require subpoena witnesses, including the officer who wrote the ticket, to attend the hearing. The court will tell me how to request a witness's appearance. I understand this will go on my driving record if I lose and traffic is checked on the front. And then at the bottom, okay, that's the third one, contested hearing. Okay, guess what, folks? You can show up to court and contest it. I don't care if the judge finds in your favor or if he finds you guilty. There's nothing in there that says you have to pay the ticket. And under the terms of a contract, the leading case in Washington State, folks, is a case called Berg versus Hudsman. Okay? Under what they call the parole evidence rule, they cannot read anything into a contract that is not there. What is not included is excluded under Washington law. Guess what, folks? Everybody volunteers to pay a ticket because they're suckers. And you want something else to back it up? Well, look at IRLJ 2.4, response to notice. Generally, a person who has been served with a notice of infraction must respond to the notice within 15 days of the date the notice is personally served. Or if the notice is served by mail, within 18 days of the date the notice is mailed. B, alternatives. A person may respond to a notice of infraction by 1, paying the amount of the monetary penalty in accordance with applicable law, in which case the court shall enter a judgment that the defendant has committed an infraction. Okay, like I said, the first choice is for the suckers. 2, contesting the determination that an infraction occurred by requesting hearing in accordance with applicable law. Okay, that's the third one on the ticket. They make it the second one in the infraction rule. Okay, well, doesn't say there you have to pay either. 3, requesting a hearing to explain mitigating circumstances surrounding the commission of the infraction in accordance with applicable laws. Or 4, submitting a written statement either contesting the infraction or explaining mitigating circumstances if this alternative is authorized by a local court rule. The statement shall contain the person's promise to pay the monetary penalty authorized by law if the infraction is found to be committed. For contested hearing, the statement shall be executed in substantially the following form. I hereby state as follows: I promise that it is determined that I committed an infraction for which I was cited. I will pay the monetary penalty authorized by law and assessed by court. I certify or declare under penalty of perjury under the laws of Washington that the foregoing is true and correct. Date and place of your signature. I understand that this form is submitted by email. My typed name on the signature line will qualify as my signature for purposes of the above certification. For mitigation hearings, the statement shall be executed in substantially the following form. I hereby state as follows. I promise to pay the monetary penalty authorized by law or at the discretion of the court any reduced penalty that may be set. I certify, declare under penalty of perjury under the laws of the state of Washington that the foregoing is true and correct. Date and place of and signature. I understand that if this form is submitted by email, my typed name on the signature line will be qualified as my signature for purposes of the above certification. C, method of response. A person may respond to a notice of infraction either personally or, if allowed by local court rule, by mail or by email. If the response is mailed or emailed, it must be postmarked or emailed not later than midnight of the day the response is due. Well, folks, go back and look at your green ticket. The first one, enclosing a check, that's for the suckers who just want to avoid a court appearance. They can volunteer to send money if they're stupid. 2, the mitigation hearing, same thing. That's for the suckers who volunteering to pay the ticket, but they're pleading guilty and they're just bleeding to the judge like a sheep. Your Honor, please lower the fine. But the third one, contested hearing. You just send in a notice saying you contest the hearing, but there's nothing in there that says that you promised to pay. Okay? They may have put something in the IRLJ no response to notice in the court rule, but when they gave you the ticket, there's nothing on the ticket that says you have to pay or that you promised to pay. Okay? It just says my mailing address is print, name, street or P.O. box, city, state, zip code, telephone, home, work, is interpreted in any language, and then your signature is an X. There's nothing here that says that I certify or I promise that I'm going to pay. So they're tricking everybody into voluntarily paying the tickets. And the reason why that is, folks, is guess what? You can't legally pay a debt with another debt. It's an impossibility at law to pay a debt with a debt. The so-called money that's in your wallet, folks, look this up. This is real stuff. Title 18, Section 8 defines a Federal Reserve note as being an obligation of the United States. That's right. Now, look up the legal definition of the term or word obligation. In a layman's word, it means evidence of debt or credit issued. Okay? Now, you go look up Title 31 of the United States Code, Section 3124. It says obligations of the United States are not taxable by the state. That's right. Obligations of the United States are not taxable by the state. What do you think they're doing when they give you a ticket? They're taxing you. Okay? They have no authority to tax you. Okay? In obligations of the United States. You cannot pay a debt with another debt. It's an impossibility at law to pay a debt with a debt. We are being scammed, okay? By law, by statute, and the Constitution, a judge is bound to swear an oath of office to uphold the Constitution for the state of Washington and the United States Constitution, the laws of the state, and the laws of the United States. Guess what, folks? In 1898, the Washington State Territorial Supreme Court, in a case called Dennis versus Moses, okay, which is 18 Washington Reporter, page 537, February 15, 1898, citing Woodruff versus Mississippi, the leading case of the famous body of cases called the legal tender cases, the gold and silver cases. Woodruff versus Mississippi, citing Article 1, Sections 10 of the United States Constitution, says, no state shall make anything but gold and silver a tender payment for a private obligation. Guess what, folks? City of Seattle is a private corporation. The Department of Licensing is a private corporation. The state of Washington is a private corporation, and all three of them are registered on Dun and Bradstreet. This is not really the state of Washington. Okay? Look at your ticket, spelled in all capital letters. State of Washington. Okay? It's not upper and lower case, the state of Washington. Okay? There's a big difference when you put the word the, you know, and they're trying to trick people into claiming that it is. Well, guess what? The state of Washington does not exist in fact or law. And the proof of that is they have no valid constitution. All the attorneys in the state of Washington are using a fraudulent, phony, non-existent constitution. Now, the Supreme Court judges will lie to you. Okay, they're not under oath. Keep in mind, these people can lie all day long from the bench. They'll say, oh, no, Mr. Ewing's wrong. The Enabling Act allowed us to do a new constitution. Guess what, folks? Senate Bill 185, the purported Enabling Act that purported to allow Washington, North Dakota, South Dakota, and Montana to convene a second constitutional convention, frame a second constitution, and then elect a new state government. It's a one-house bill. It was never passed by both houses of Congress. Okay, so they don't exist in fact or law. We have nobody home. There's nobody running the government. The original 1878 Walla Walla Constitution is the only legitimate and valid constitution for the state of Washington. When you go read that Constitution, the 1878 Walla Walla Constitution, you can Google that and find it online, the 1878 Walla Walla Constitution. When you go read that Constitution, it says you cannot have another constitutional convention and you cannot amend this Constitution until you elect the officers of this state under this Constitution. Guess what, folks? We've never elected the state government under the original state constitution for the state of Washington. So their second constitutional convention is a complete fraud. It has no authority to exist in fact or law. In fact, it does not exist in fact or law. Okay? You want proof of it? It's going to be hard to disprove me on this, okay, because now that I've exposed this, they've assigned a state patrol to be a security guard inside the archives. They will no longer allow anybody to physically inspect the so-called original Constitution for the RCW, the one that all the attorneys are using. They will claim, oh, no, it's to protect it because it's an old document. We don't want people getting their fingerprints on it. Well, that's a bunch of crap. Okay? I'm the first person to order 4 certified copies of that Constitution, the phony RCW Constitution, the Journal of the Constitutional Convention, and the so-called election results allegedly proving that it allegedly passed. I'm also the first and only person to get 4 certified copies of the 1878 Walla Walla Constitution, the Journal of its Constitutional Convention, and its election results. Okay? Now, Lloyd Smith and David Hastings, the former archivist of Washington, told us that he'd been the archivist for 30 years. And from his memory, nobody, no judge, no prosecutor, no attorney, nobody had ever looked at the original Constitution in Washington that they're using for the RCW. We're the first ones. And it took David Hastings and Lloyd Smith about 3.5, 4 hours with rubber gloves on, peeling the pages apart one at a time, because the book had not been opened in 100-something years. The pages were sticking together. So it took them 3.5, 4 hours to peel it apart. And what proves that it's a fraudulent document, a phony constitution, folks, is it's laid out folio style. There's a blank page between the last page of that phony constitution and the signature page, which proves that nobody ever signed it. That's right. Nobody ever signed that constitution because it was not done on July 4, 1889. It was not done until 10 years later. And the proof of that is that we found a notarial seal dated 1898. 10 years later. A certified notarial seal. And we got the archivist to certify 4 copies out with the seal of the state on it. So we have absolute evidence rule 902, self-authenticating proof that the state of Washington is using a phony constitution that has no authority in fact or law, has no basis in fact or law. It does not exist in fact or law. It is a forgery and a perjury. What that means is Dixie Lee Radiation and Christine Gregoire were never the governors of this state. What that means is every woman that holds a public office does not hold a public office. Every person that has ever been sent to jail by a woman judge has been falsely arrested and falsely imprisoned because women have no standing under the law to hold an elected position in any public official position within the state of Washington. That's right, folks. That is a legal fact, and the judges are hiding it. They've now assigned a state patrol person to be the guard dog at the archives. Nice guy, though. but nobody was allowed to look at it. But I have certified copies of it, this stuff. So we also went to Washington, D.C. to dig up more proof of this. We got the National Military Archives. The main archivist there, name is Rodney Ross. This was over 10 years ago. He told us then that he was supposed to retire that year. And because of the big hubbub of the constitutions, because we went around to many other states' archives, folks, and this, it's funny, it's always a Jewish person that seems to be running these archives. And it scared the shit out of several archivists, especially the ladies. They were wondering, why do you want to look at the original constitutions? And I'm looking at these people and I'm saying, because that's the only valid constitution for the state. I said, all the Jewish attorneys are the ones who met behind closed doors and subverted our constitutions, committed treason against the people. And they forced all the states to write new constitutions at the end of the Civil War in 1860 when we lost the war to the British. That's right, folks. Every single state within the United States, okay, has suspended their first original de jure state constitution and replaced it with the new phony statutory constitution. Now, some people say, what difference does it make? It's just a piece of paper. Well, you're right. You're right. If they're using a phony constitution that has no basis in fact or law. Well, people say, well, what's the difference? Okay, folks, the difference is under the original 1878 Walla Walla Constitution, you wouldn't have to get a job, fill out a W-2, W-4, give your Social Security number, which is the mark of the beast under 42 U.S.C. 666, and apply for a job as an employee of an employer who is a United States corporation, which is a political subdivision of the corporate United States, and volunteer to be a slave and pay taxes to the Jewish masters who wrote the tax laws. And you wouldn't have to go to a bank owned by all the Jewish bankers and apply for a loan to borrow their phony money and sign a contract to be an indentured servant, a slave for the next 30 years of your life to buy a house. And people say, oh, I own my house. Well, folks, I don't care if you had a mortgage burning party. And by the way, folks, when's the last time you heard of anybody having a mortgage burning party? Apparently, see, all the attorneys, they're just so greedy, they won't let us have mortgages anymore. So they wrote up a nice, pretty document called a trust deed. Do you really trust attorneys? Well, they're the ones who wrote trust deeds. Okay? They don't give mortgages anymore because it takes them too long to kick you out of the house when you stop paying rent. Because that's what you are, folks. You are not homeowners. You are renters on the land. You are feudal tenants. You are slaves. And Thomas Jefferson said it best. There is no better than the slave who thinks he's free. I guarantee you, folks, you can't prove me wrong. I challenge anybody to prove me wrong. If you're stupid enough, stop paying property taxes on your property. Guess what? The government will come remove you and your parents and your grandparents from your so-called house that you think you paid for. You think you own your house free and clear? Stop paying the property taxes. I guarantee you this corrupt government will come remove you from the land because it does not belong to you. But under the original constitutions, folks, we could own the property in allodium. That's why they hid and suspended and archived the original constitutions. They didn't want us owning land. Okay? That national forest out there, that's BS. Google the word national forest. You know what it means? It means the Queen's forest. What kind of bullshit is that? Sorry, I didn't mean to cuss. But what kind of nonsense is that? Okay? We're supposed to be able to homestead land. People say, oh, no, they repealed the homestead laws. No, they didn't. They did not repeal the homestead laws. The United States Code, okay, is the prima facie evidence of the law. It's the statutory codification of the underlying acts of Congress. The underlying acts of Congress is the original session law passed by the last legitimate legislative body, just like the state of Washington. Okay? The only legitimate law in the state of Washington is the Territorial Code of 1881. The last printing of it was in 1889. But we have not had any laws passed in this state or territory of Washington. Technically, folks, we're still a territory. They flipped us back into a territorial status. Go look up in the current RCW, murder, robbery, theft, burglary. In the footnotes, you'll find references to the Territorial Code of 1881. That's the actual session law passed by a legitimate legislature. Those are the laws. All the current RCWs are not the laws. But under the original Land Grant Act, folks, we would be able to claim 1 square mile, 640 acres of land, 320 acres for the man, and 320 acres for the woman who is under the control and power and authority of a man. Sorry, but women could not own land in their own right. The husband died. If a man wanted that land, she had to sell it. The only way she could hold on to it is if she had some underage sons who were the inheritance of her dead husband, former dead husband's property. But if she didn't have any sons, that property was up for grabs for any man that wanted to come and take it, because women were back then considered the chattel property of men. And the women are all up in the rears about that. And I said, really? Well, now, who would you rather be the property of, your man or the property of the government? This is why CPS can come take your children, because you are the property of the government. The government is our mommy and daddy. You're no longer a grown adult. They see you as children. They can come take your children and sell them because, well, basically the judges and the assistant attorney generals, they're a bunch of homosexuals and lesbians who've infiltrated the government, who are recruiting lesbians to gain employment with CPS, and the homos are whispering in their ear saying, I want that one, I want that one, I want that one. And former King County Sheriff David Reichert testified before Congress that we need money. There's nothing in federal law to prevent all these children from being molested. 6 out of every 10 children in the CPS foster care in the state of Washington are being recruited straight into the sex trade industry and the child pornography industry, and we have nothing to protect them under state or federal law. Folks, I can send you a list of statutes showing that they set up CPS on purpose. Okay? Nancy Schaefer, former governor, former legislator for the state of Georgia, and her husband were assassinated for 2 main reasons. Number one, she connected the gay rights movement to CPS and proved that these people were recruiting children to be recruited into the sex trade industry, child sex trade industry, and child pornography industry. And she connected the dots financially, proving that these people were double dipping and triple dipping and defrauding the federal government out of money using the children. They go snatch all the children under the color of law, and then the state government, CPS, social workers, are waving their hands into the federal government. We have all these children. We need money. We need money to take care of these children. And so they're defrauding the federal government. They have a special group of accountants that work for CPS, a bunch of criminal accountants, that monitor the accounts, that when they get up to $2,000, right before they hit the $2,000 mark, they sweep the account dry. Then the social workers are going, we need more money, we need more money. And then they keep sending, then they get the federal government to send them more money. And I found case law, folks. I'll send you a list of it. 3 cases, 2 Supreme Court decisions for Washington. In between that, it went to the U.S. Supreme Court, a case called Keffler, where they publicly admitted to their crimes, that they did a random of account with like 50, 49, 50-something accounts of over $750,000 something dollars that was allocated toward children. Over $680,000 went missing. And a short blurb in the case, CPS does not keep accurate records of where this money goes. Okay, so are the social workers and the guardian ad litems and the judges and the assistant attorney generals and all the public defenders, are they having vacations in foreign countries? Are they meeting at the whorehouses in Europe where they have sex, legalized prostitution hotels where they can have sex with young children? Is that what they're doing? Are they selecting out the children who they want to have sex with over when they get over to one of the hostels, like you've seen in the movie Hostel? It's crazy. Okay, but back to the thing on the scam, the overall scam. We're being deprived of our rights. Okay, under the original constitutions, we would be able to own land in a allodial title. 1 square mile, folks. You wouldn't need to go get a job, save up 20% down payment, sign a contract to be a slave to some Jewish banker for the next 30 years of your life. I want to uncover this, so I'm looking for donations, but I want to reveal this to the world, that we're going to be able to go to the national forest and file a land patent. Okay? They did not repeal the original acts of Congress. They only repealed the statutes. Okay? You want to be a slave? I would rather say, you know what, here's my house. Instead of like taking this job and shove it, take my keys and go to the bank. For all those people who think they want to be homeowners, imagine this, if everybody went in droves and they said, well, I'm going to stop making house payments. Here's my house keys. Walk up to the bank and say, here's the keys back to the house. I'm rescinding my signature on your trust deed application, your mortgage application. I'm not going to be making payments anymore. And besides, I'm moving out because I'm going to go claim 1 square mile of land. That doesn't mean you go chop down all the trees in the national forest, but folks, within reasonable limits, you should be able. The law says even on gold mining laws, land patent laws. I've discovered this too. The land patent, the gold mining laws are still valid laws. You could work a claim in the river with a gold pan. Doesn't matter if there's a lot of gold. You could actually work the claim. Under the gold mining laws, you're allowed to cut a path through the woods. You know how much a log load of fur is worth? You could make enough money just like cutting a little road back, 100 yards or something into your property. You got 1 square mile of land. And there's a back section here where you don't really like to timber anyway, and it would be perfect for grazing for your cattle. Why not cut down 10, 15, 20 acres of land? You know how much fur that is? Free fur. A log load could be worth $3,000, $4,000, $5,000, folks, depending on it's number 1, 2, 3 grade of fur. Free. Imagine being able to go cut wood down for free. With that money now, you could hire a home builder to come and build you a house. You build a fence for your cattle. You could actually buy some cattle with the free wood that you got off your own land. And you don't want to go chopping down all the trees, just enough trees to, build a little ranch for your horses and your cows and your chickens and to build a nice log cabin house. You could clear off 20, 30 acres for that, no problem. You could probably build a $500,000 house for free within 1 to 2 years, and you would not be making mortgage payments as a slave for the next 30 years of your life. And they've hidden that from us. We have been robbed of the American dream. And it all started with a little Jew named Joseph Lieber. Joseph Lieber, who probably with a gun to Abraham Lincoln's head, forced the declaration of martial law in the United States. Go look it up, folks, the Lieber Code. We have lived under a permanent provisional military government ever since Abraham Lincoln first declared martial law. The Lieber Code lays it out that until a president issues a proclamation that the war is over, that war continues in perpetuity. Perpetuity. Every single president for the United States, when he's elected, the very first executive order he signs is an executive order continuing the emergency. And you want to go look it up? Go look up a case called Luther versus Borden. Luther versus Borden, Luthor, Luther versus Borden, Borden, and also look up another case called Texas versus White. Those two cases together, when you read it both, you're going to realize that we live under martial law. We live in a permanent provisional military government. And to support that has happened in all the states, well, folks, go look in your state statutes. Here in Washington, folks, you can look up, Google the Revised Code of Washington. Just Google that up. Now scroll down through the statutes and look for number 38. 38 is entitled Militia and Military Affairs. You want proof that they've subverted the Constitution? You hear the judges lie to you in open court and tell you you have a right to be represented. That's nonsense, folks. The Sixth Amendment to the United States Constitution says you have the right to the assistance of counsel. Assistance of counsel means co-counsel. Okay? Doesn't mean representation. Representation and assistance of counsel are mutually exclusive terms. They are not synonymous terms. These people are violating their oath of office, okay, to uphold the state constitution, the federal constitution, the laws of the states, and the laws of the United States. So back to what I was saying about Title 18, Section 8. It says a Federal Reserve note is an obligation of the United States. And 31 U.S.C. 3124 okay, which used to come from 31 U.S.C. 742, where it says this exemption extends to every form of taxation that would require that either the obligation or the interest thereon or both be considered directly or indirectly in the computation of the tax. Now, in a case called American Bank and Trust Company et al. Versus Dallas County, it says, under the plain language of the 1959 amendment, however, that tax is barred, regardless of its form, if federal obligations must be considered either directly or indirectly in computing the tax. Giving the words of an amended Section 3701 their ordinary meaning, there can be no question that federal obligations were considered in computing the bank shares tax at issue here. That's American Bank and Trust Company et al. Versus Dallas County et al., which is 480 U.S. Reporter, page 855, Supreme Court Report Lawyers Edition, page 3369. Okay, so Justice Blackmun further argued that since Congress expressly excluded franchise, estate, and inheritance taxes from the exemption, he said, quote, Congress must have believed that such taxes required federal obligations to be considered directly or indirectly in the computation of the tax. Otherwise, the specific exemption of these taxes would have been superfluous. Wow. So how can they tax this? If obligations, if Federal Reserve notes are obligations of the United States under Title 18, Section 8, and under 31 U.S.C. 3124, obligations of the United States are not taxable by the state, how in the hell can they get us to pay a fine? Dennis versus Moses says, quote, the power of the state to declare a legal tender is limited to gold and silver coin. All lawful money of the United States is not a legal tender for private obligations by the laws of the United States. The legal tender and gold contract decisions taken in connection with the recent case of Woodruff versus Mississippi, 162 U.S. Reporter, page 291, are controlling here. Okay, so I'm going to read you guys some statutes that you've never heard of that the criminally corrupt bar associations are removing from the law libraries every year. They're amending the code. That doesn't mean they change the law. Amend the code when they omit something, folks. Guess what? Title 1 RCW 04.010 through 20 says, in case of any inconsistencies or omissions, the previously existing law shall control. Now, the bar attorneys will lie to you, okay? Title 31 United States Code Section 371 says, the money of account of the United States shall be expressed in dollars or units, dimes or tenths, cents or hundredth part of a dollar. And all proceedings in the court shall be kept and had in conformity to this regulation. Title 31 U.S. Code Section 311 says, it is declared to be the policy of the United States to continue the use of both gold and silver as standard money. Folks, the Mint and Coinage Act of 1792 has never been repealed. The laws on the books that says money is supposed to be gold and silver has never been repealed. It's actually, the laws still say it's supposed to say payable to the bearer in demand and redeemable in gold and silver. Those laws have never been changed. But guess what? We turned over the printing of our money to a private corporation called the Federal Reserve. Folks, the Federal Reserve is not federal. It's not any more federal than Federal Express or UPS. Okay, it is a private corporation. It is not even part of the United States government. Okay, and all these Jewish bankers, the Federal Reserve notes are actually in violation of the Organic Act, Section 6 for the Territory of Washington, which says that nothing in this act shall be construed to give power to incorporate a bank or any institution with banking powers, or to borrow money in the name of the territory, or to pledge the faith of the people of the same for any loan, whatever, directly or indirectly. No charter granting any privilege of making, issuing, or putting into circulation any notes or bills in the like list of banknotes, or any bonds, scrip, draft, bill of exchange, or obligations. There you go, folks, obligation. That's what the Federal Reserve note is. It is a Title 18, Section 8 obligation in the United States. Or granting any other banking powers or privileges shall be passed by the Legislative Assembly, nor shall the establishment of any branch or agency of any such corporation derived from other authority be allowed in said territory, nor shall said Legislative Assembly authorize the issue of any obligation, scrip, or evidence of debt by said territory in any mode or manner whatever, except certificates for service to said territory. And all such law or any law or laws inconsistent with the provisions of this act shall be utterly null and void. Folks, everybody's watching Scooby-Doo. Everybody's watching Final Four basketball. Everybody's watching American Idol and So You Think You Can Dance, and nobody reads books anymore. I happen to fall in love with reading from reading comic books when I was a kid, and I've never stopped reading since. So, folks, get your kids to start reading comic books so that they learn how to read. Okay? The kids these days, they know how to play video games. They know how to use your iPod. They can use your cell phone better than you can. But they can't fucking read. Okay? You need to teach your children to put that crap away and for them to start reading books, or we're never going to regain this country. We're not going to get our rights back because everybody's been dumbed down. And they're going to tell you, well, you need to hire an attorney who's a member of the bar to represent you. Okay? They're not representing your best interest. They're representing their best interest, and they want it. You go into court, they want you to fill out a financial application. They want you to tell where you work, the address of your employer, the phone number. When your kid gets charged with a crime and you go to Raymond Hall in Tacoma, they're filling out they're handing you these applications to declare your financial status, because don't worry about it, folks. You're not innocent till proven guilty. You're guilty till proven innocent. And don't worry, okay? We just want to know where to start garnishing your paycheck, because we're going to find your kid guilty because we need your money. Okay? You want more proof that these gold arguments are legitimate argument? This has been argued as recently as 1986 and 1987. Some rich, crooked attorneys working for Frederick Nelson. You folks remember the Frederick Nelson building? Home delivery furniture in Washington State? Okay, like Bon Marché and Nordstrom's. Frederick Nelson's was owned by the Fay Corporation. Okay? Here's a case called the Fay Corporation, a Washington corporation, plaintiff versus BAT Holdings No. 1, Inc., also known as the Marshall Field Company, a Delaware corporation, and Frederick Nelson Seattle, a Delaware corporation. The holding of gold remained prohibited until 1973, when Congress repealed the 1934 ban on private ownership of gold, 87 Stat 352, 1973, as amended by 88 Stat 445, 1974. But did not address the 1933 prohibition of gold clauses. This omission was remedied in 1982 when the statute was adopted. 31 United States Code 5118, subsection D2, 1983, hereinafter referred to as section 5118. The language provided that obligations covered by gold clauses prior to 1977 are, as before, dischargeable dollar for dollar with the United States currency. Gold clauses are enforceable after October 27, 1977, pursuant to Section 5118. Therefore,